For a motion to bind over, I believe that the facts set up everything that's needed for count one, as it clearly shows that it's a controlled substance, it's cocaine. It was tested by the True Narc. In this case, Officer Hussein testified about finding the narcotic residue inside the vehicle. Then the two larger bags, which were found at the hospital. In this matter, the defendant was the only one in the bathroom at the time in which these narcotics, or prior to these narcotics being discovered. He was informed not to flush the toilet, did so anyway, was also informed not to basically make sure that he could be visualized. In this case, he saw that he bladed himself towards the trash can, away from the view. There was fervent movements with his hands, and then all of a sudden there happened to be, while he washed his hands, there's two baggies of one bag of cocaine, one bag of crack. It just happened to be wet at the time in which, generally right after he washes his hands, Your Honor. So it's been tested and shown as far as count one is concerned. But when it comes to count two, Your Honor, I believe...
All right, let's skip the small talk and get right to the point. We're looking at a serious case here, and the evidence is overwhelming. Lab tests confirmed the presence of cocaine. It wasn't speculation. It was tested, bagged, and tracked. Officer Hussein also noticed drug residue in the vehicle. Things escalated at the hospital. Two separate bags were found, and the suspect was caught in the restroom. Despite being told not to, he tried to flush something. Right after, he was seen making suspicious movements near the trash soon after. Two wet baggies were recovered, both containing cocaine and crack. The timing of it all, it's too precise to be a coincidence.
Officer Hussein's testimony is very relevant into the indications of narcotic trafficking in cells. It's our position, Your Honor, based on the fact that there was a scale there, multiple small baggies numerous small baggies for packaging, tear-offs, which are commonly used as packaging, two different types of narcotics placed in two different bags, both of which are above the normal use for personal use. In this matter, we have one at 14, I believe one at 30 grams, Your Honor. One of those, I believe, which would be the cocaine, this pure cocaine, Your Honor, 30 grams, that's over an ounce. He had over an ounce of cocaine and then approximately half an ounce of crack cocaine, Your Honor, with baggies, with the scale. Those are every single thing beyond our address book that one would need for distribution, Your Honor. So we do believe that there is more than enough probable cause to sustain the additional charge that the people had requested, which was...
Disco Cossacks. But now, pay close attention. This next part is important. We're not talking about personal use here. This is a trafficking situation. Officer Hussein explained it clearly. There were digital scales, lots of small baggies and packaging materials, everything you'd expect. In a street-level drug operation, and it wasn't just one type of drug. There were two cocaine and crack, each in separate bags, and it wasn't a small amount either. Authorities found more than 30 grams of cocaine and almost half an ounce of crack, all packaged and ready. For distribution, when you put the amount together with the packaging, it's obvious this wasn't for personal use. The evidence clearly points to intent to sell. There was more than enough reason for probable cause. This was no minor offense. It was a full-blown distribution.
A possession with the intent to deliver, which would be a delivery of manufactured and controlled substance less than 50 grams. We showed that the total weight of this was 45 grams, Your Honor, just under that 50-gram threshold, and that it was all cocaine or a mixture that contains cocaine, Your Honor. So for those reasons, and of course, we've already established venue, time, location, and identity. So, Your Honor, at this point, we do ask that the court bind over on the original count one and the added count two of delivery and manufacturing of a controlled substance less than 50 grams.
Thank you. The first element of this, of course, is that the defendant possessed controlled substance, in this case, the allegations, cocaine and crack cocaine. There was a pat down and a full search before the hospital, before any of these allegations happened, by trained law enforcement officers. They know how to do the searches.
SH. Bonal, let S. Look at the other side of the argument. The defense, they're focusing on one major point. When the officers searched the suspect, they didn't find anything on him. Nothing in his clothes, nothing in his pockets, and no illegal substances in his system. It's completely clean. That's the defense's strategy. They're saying the officers checked him thoroughly before the hospital visit. So if he didn't have anything on him then, how did those drugs end up in the trash? They're leaning heavily on reasonable doubt. The bathroom where the bags were found was public, no cameras, no security, and anyone could have gone in. So their argument is simple. Anyone could have put those bags there. That's the story they're standing by.
Well, Officer Colorasi was in training, but also trained to do a search, obviously. Nothing was found on my client's person. Nothing in his system from the blood draw. No drugs, no alcohol. So really the possession comes down to these two bags that were found in the trash can in the hospital bathroom. A bathroom that is open to the public 24/7, doesn't require any special entry. Anyone could walk into that hospital and use that bathroom. I was curious how often they cleared the trash can, but the officer from the hospital didn't know. So obviously those bags could have been there for any amount of time. The officer from the hospital testified that my client had irregular hand movements, but
But hold on, this case isn't closed just yet. Yes, it was a public restroom. And yes, anyone could walk in. But here's the detail that stands out. The drugs were found in the trash can, right after the suspect spent an unusual amount of time drying his hands. Hospital staff noticed this strange behavior. It didn't look like someone simply drying off. It looked like someone stalling for time or possibly hiding something now. No one saw him actually throw anything away. But the timing, it was too perfect to ignore. And those baggies were wet, like they'd just been tossed moments before being discovered. Coincidence? It's hard to believe. It raises serious doubts and makes the situation look even more suspicious.
at the end of the day, all he said was, well, he was drying his hands for an irregular amount of time or something to that effect. I mean, that's, I just, I just don't think there's a lot there to support probable cause, respectfully. And no one saw my client put anything in the trash can. And of course, Your Honor knows there's two types of possession, right? Actual and constructive. Presumably the people are arguing both, that he actually possessed these, but, that nothing was found on his person. Constructive possession is, of course, and then there's case law, I think Mr. Danner is aware of. There's a Sixth Circuit case interpreting Michigan law, and then there's a Michigan Supreme Court case, and I have the citations, I'll mention it quickly, but basically proximity to contraband is not sufficient proof for possession, for constructive possession.
Both Moeski, both, now we're entering the legal back and forth. This is where things get strategic. The defense is making a strong legal argument. In Michigan, just being near drugs isn't enough to prove possession. The law requires more than proximity. It demands clear signs of control, intent, or ownership. They're backing this up by referencing major court decisions, including Parker v. Reno and People v. Wolf. These cases carry serious legal weight. Their point is straightforward. There's no direct connection between the suspect and the drugs. No fingerprints, no weapon. No one actually saw him plant anything without solid evidence linking him to the stash. The claim of constructive possession, meaning indirect control, just doesn't hold up. It's a tight legal standard, and the defense is leaning hard on that line.
There has to be something else connecting a defendant to the contraband, whether it's a weapon or a controlled substance. And I won't go through a lot, but I would just like to, for the record, say that I'm referring to a Sixth Circuit case, Parker v. Renico, 506 F3rd 444, interpreting Michigan law, decided October 17, 2007. And that case cites many cases, including a Michigan Supreme Court case, People v. Wolf, WLFE 440 Mich 508, decided in August 31st, 1992. Very briefly, what the Sixth Circuit says is, as with the federal rule, a person has constructive possession if there's proximity to the contraband, together with indicia of control. In other words, proximity alone never suffices. Cites a Michigan Supreme Court case. And
Expiolettes. Be honest, this isn't a courtroom drama. It's real life. And the defense is pushing that point hard. They're reminding the court that no one actually saw the suspect throw anything away. There were no fingerprints, no confession, just assumptions. They continue to stress the difference between actual possession and constructive possession. And here's the key: even constructive possession still requires real evidence. Michigan law doesn't go off suspicion. It requires a clear link between the person and the drugs. The suspect may have been nearby, but the defense argues that doesn't mean he had control over the drugs. That's their strategy, to steer the case into reasonable doubt. And if they succeed, that could be enough to change the outcome.
the ultimate question, according to the Michigan Supreme Court, is whether the evidence establishes a sufficient connection between the defendant and the contraband to support the inference that the defendant exercised dominion and control over the substance. That's beyond the mere proximity. So I respectfully assert that there is not probable cause on that first element for actual or constructive possession. The second element, defendant knew that he possessed a controlled substance. That would have to be inferred. There's no evidence of that. There's no statements or admissions. So that would have to be inferred from the first element. And, well, there is testimony of the weight. So that's the third element. So for all those reasons, well, I'll leave it at that. Thank you.
I really don't need rebuttal.
H. B.O. now let. S. move from arguments to action. Here's what the judge actually decided. The court made it clear there is probable cause. In other words, there's enough solid evidence to believe the suspect not only had drugs but intended to sell them. The judge pointed to several key pieces: the baggies, the suspicious movements, and the witness statements. Taken together, they meet the legal standard to move forward. This wasn't a final verdict, but it was a serious step. The judge acknowledged the concerns raised by the defense, but said those are issues for a jury to weigh. Bottom line, the case isn't being thrown out. There's no free pass. It's going to trial.
The court would find that the people have sustained their burden of showing sufficient evidence that there's probable cause to believe that the defendant committed the offense of possession of a narcotic less than 25 grams. Also, given all of the testimony, in particular that by Officer Hussein, there is enough. This court believes that the defendant should also be bound to stand trial on the additional charge of possession with intent to deliver a controlled substance less than 50 grams. And so the court would bind the defendant over to circuit court on both those counts. The court would also indicate that the issues that are raised by the defendant with regards to those cases and actual possession, the court does find, for the purposes of probable cause, that those particular prongs under either test are met. To the extent there might be an argument as to what could be inferred or the intent, that this court would believe would become a question of fact that would properly be before the jury. But I think there's enough there to bind the defendant. Well, I know there's enough there to bind the defendant over. Defendant's bound over on counts 1 and 2.
Go on with that. The final decision is in. There's no turning back now. The judge has officially ordered the case to move to circuit court. Both charges are moving forward: possession and possession with intent. To deliver that the court wasn't swayed by distractions, the officer's testimony, the timing, the amount of drugs, it all held firm. Even with the defense's sharp legal arguments, the foundation of the case stood strong. This isn't about maybe anymore. The court believes there's enough evidence for a full trial. Now, it's in the hands of a jury. The courtroom battle isn't over. It's just entering the next phase.